I'll reserve 12 minutes for rebuttal. May it please the court. My name is Todd Skoglund. I represent the log plaintiffs as assignees of Highmark Homes. There's two main issues before this court today. The first I'll cover is the duty to indemnify the interpretation of the tract house endorsement. It is our opinion the district court read it as broad as possible, which is against Washington law. It specifically says they can build up to 25 or more houses within a time frame. Facts matter.
Where does it say within the time frame?
20.
I mean, the language doesn't, as I read it, doesn't have a time frame to it.
It does not, Your Honor. It does not have a time frame. That's why I said the district courts read it as broad as possible. It does have a policy period. They bought a policy period. The district court cited Seattle Tunnel, which is the case building the tunnel downtown, which is a project policy, which is 72, I think it was 72 or 78 months long because of the project. And that's the case it cites. If you read the opinion, you won't see that time frame in it. You have to go back and pull the record and the actual policy. But if you flip through the policy referenced in the Seattle Tunnel case, Seattle Partners Tunnel case, it'll tell you it's 78. It's a policy, a project policy, which extended the entire project. Which this is a standard CGL policy, which is a one-year policy, which ran from 7/16, 2010 to 2011, 11 to 12, 7/16, 12 to 13. There was 4 houses built in the second policy. I'll just refer to the second policy period.
You agreed that there were 25 or more residential buildings that were built in the development.
I wouldn't concede it's a development, Your Honor. If you read the first part of my argument, each house that development was submitted by a different developer, and then the Highmark Homes came in and it submitted individual certificates or individual plans for every house built, and he treated every project as a house. And then he submitted another house, and then another house. And that's how he read the policy. So he decided, or he defines a project as a house, which is a standard term. Use a house as a project, could be a number of projects. And the term most favorable to the insurer or insured is the term the court should use, not the one that the developer wants to use. And they want to use project.
So isn't the policy uses the term phase? A phase?
Yes, phase or development.
Yes. Why doesn't that cover it?
How many phases is there? Build a table or a chair, Your Honor? You could build, a phase could be, this court has phases. It has a discovery phase. It has a opening statement phase.
Well, it's not real. It's not realistic. Well, maybe it is with some builders, but it seems hard to imagine that a builder could build 25 homes in 1 year.
As in the intro of this motion says, there's 4. Actually, this builder, if you look at the project at the beginning of this motion, you'll see there's 4 projects being at issue.
Yes, there's several other cases.
He actually, I don't know the exact number in my head, but he had projects going on, individual houses building all over the place. A lot of these projects were combined. If you actually combined all the different projects.
Can you slow down just a little bit? I'm having some difficulty following you, so maybe just slow down.
Yes, Your Honor.
Thank you.
And so the way there was actually a lot more than 25 projects going on at the same time. He's built, if you looked at all the projects, he contracted per home or project. Every contract there wasn't 5 homes at a time. Each house, if you look at the facts, and these facts are undisputed, Your Honor. There's no dispute here. He contracted every house as a single project. There was a single framer for that project, a single plumber, a single roofer. As soon as that house was built and the city approved another house, he would he would put out for bid, I should say, the roofing, the framing, the plumbing, and so that house or project would be done individually. These facts are not disputed. So he did not build this as a project. And all the literature I supplied to the court, and there was no counter testimony to this, must be noted to the court that they produced no evidence in this case except for their lawyers' arguments.
Can I just read you the policy and then work from there?
Yes, sir.
We know that tract housing is excluded from coverage. Now, the question is, what is tract housing? Tract housing is defined, and I'm at 14 ER 3773, and I'm just reading. Tract housing is defined as follows. Tract housing or tract housing project or development means any housing project or development that includes the construction, repair, or remodel of 25 or more residential buildings by our insured in any or all phases of the project or development. So why is this not tract housing under that definition?
Because the way my client defined it is one policy period. The average person.
No, I don't care how your client does it. Give me an argument as to why this is not tract housing. That's not how you're. I mean, that wasn't quite responsive to me. So why is this not tract housing? He built 25 houses or contributed to the building within the meaning of this phrase of 25 houses. So why isn't it tract housing?
Because I've done it in a policy period. And if they wanted a policy period, they have an obligation for a policy period.
But in this language, there's no limitation as to policy period. It just says tract housing, and here's what tract housing is.
Then if you read the first three or four pages of the policy, it says you must read this entire policy as a whole.
Well, of course, you always have to do that.
But in big, bold letters.
Even if it were in tiny letters, I understand that.
So if you built 4 houses, like this developer did, that four houses, right? And the policy ends. 4 houses. So he built 20... and they built 21 houses in the next policy period. Why would the average person say that has no connection to this phase of project, even if you want to call it a phase of project, in that policy period, why would you assume that? You're reading the language as broad as possible. And the state of Washington says, no, you read that narrow. You keep it within the year. If you want a Seattle Tunnel partner case.
So what language do we use to read in that 1 year limitation?
The policy period. The policy period, Your Honor. And why would an average person assume that
you basically, but taking Judge Fletcher's question where he pointed you directly, he read the language from the policy that's in play here. You're basically saying we need to rewrite that to add in within a year or within the policy period.
I'm asking the court to look at the policy as a whole and the policy period and that together. And when you read the exclusion and the policy period together, the average person would not assume a policy that had no coverage of that next policy. No, there's no coverage. This is a CGL policy, single-family housing, not an apartment project where you'd have a continuation over policy periods. There's a distinct ending period when a house is built.
What do we do with the fact that Highmark itself informed TIG that Highmark worked on 25 tract homes? I'm looking at 4ER 747. This is a statement of the builder that they worked on 25 tract homes.
I'm not sure the phrase, I'll look when counsel's speaking, but I would still argue that they thought the time frame was when tract homes are in that time frame, i.e., once again, the Seattle Tunnel case. You want the whole period? Are all the houses covered in the whole project or whole development? You say no time frame. They paid a premium for coverage. They built 4 houses. So now there's no coverage for those 4 houses under this court's analysis, or what I'm referring to the court's questions, or the 21 houses. It bought coverage for up to 48 houses, and it got coverage for 25 houses, is how I look at that phrase. Because each policy, so you build up to 25 houses, right? So each policy, you build up to 24 houses, right? So up to 24 houses, they did so at 4 and 21. Under 2 different policies, they're covered. Unless...
So I think your argument is essentially that we should be reading in language in the policy that doesn't exist to be able to think about this as a per policy development as opposed to the entire period of all the policies combined, correct?
That's exactly what I'm arguing.
Okay, so I'm going to actually move you to a different issue because you're short on time and you wanted to reserve some of your time for rebuttal. I want to ask you about the bad faith claims and the fact that it seems to me that some of the theories for your bad faith claim that you're raising now on appeal were never raised before the lower court. And in fact, sir, just let me finish my question. There was a motion for leave to amend the complaint that included the very theories that are now being argued to this court, and they were not permitted to be added to the complaint through a motion to amend. So I want to understand, and I'm particularly, confused about this issue because you all make these arguments that weren't raised below, and your friends on the other side don't actually raise the fact that you didn't raise these theories below, and they address the merits of them, which I'm not understanding why. But what do we do with this fact now that you are asking us to decide issues that were not only not raised, but were explicitly rejected in your motion for leave to amend? Can we address those? Why should we address those? Are they forfeited?
If they were briefed in the lower court, I believe they are before this court. And the reason it
Well,
gets a
they're
little
not
convoluted-
briefed to the lower court. They, in fact, were not permitted to be included in your complaint.
Not all of them. And I would argue twofold. First, the duty to defend is very broad. And yes, I did not know that they fired their counsel, and there's some other things weren't known at the time that the accusations were made. But that doesn't preclude the fact this court could consider them when they were briefed, and they are before the court. And I would, as far as we're on these claims, once again, there's no evidence contrary to the positions taken. And so as far as the bad faith claims and then firing their counsel and getting new counsel and then paying half the cost for the new counsel and putting all the costs on the other insurer, that is actually a motion for, there's a motion in front of the Ninth Circuit on whether or not that should be heard by the state court. I don't know if the court's aware of that.
A certification.
Yes, a
request.
certification. And so the issue was raised in another motion, maybe not directly. And the reason it kind of gets convoluted is the three cases, there's overlapping arguments, and I know they're all separate cases, and maybe they should have been consolidated. Looking back at them all, Your Honor, they're more similar than thought, but that, you don't find that out until discovery. And once discovery goes, you start understanding the different arguments and how they are all intertwined. But I just want to be clear on, they're asking you to broad language on a CGL annual policy period to cover events that aren't covered outside of policy. It'd be no different than a car wreck in one policy, then you get a car wreck later, you say, well, they're both covered. They see two car wrecks.
Let me just ask let me ask you one question. So,
Yes.
There was an earlier case that we decided, the Ninth Circuit decided. Hey.
Yep. Very familiar with it, Your Honor.
Yeah, you were probably counsel on that case,
Yes, it
right?
was.
And it's the same policy provision,
Yep.
correct?
Yep.
I think it's the same project, too.
Different project, but same time frame.
Same time frame.
Yeah, that's
Okay.
Yeah.
But the same policy provision.
Yep.
The panel in that case didn't buy your argument.
The argument wasn't made, Your Honor.
Was
Why
not
it wasn't
made?
made? Because 25 houses were actually certified for occupancy within one policy period. So you can't make the argument two policies were triggered. There's 25 houses built in one policy period. Under their policy, occurrence has to occur within the policy, right? It was, and they were certified for occupancy in one policy period. So it was stuck in one policy period. You couldn't make the argument that you're stretching it into another policy period to trigger your coverage. That is the quintessential difference in all these cases. And there's different factual scenarios in each of these cases. That's where I think the Hay case is, that broad statement the court made is incorrect. There's other cases out there that there's other insurers after this policy. So 20 houses were built, or rough figure, but other houses were built while insured by another insurer to get 25. And so how far are you going to stretch this? And I know the court doesn't like hypotheticals and doesn't really look at them, but that's where the Hay court, that broad decision, that would, with all due respect to Judge Lasnik, that broad statement should be made in a Washington court because facts matter, and every case affects an exclusion different.
It's just, the Ninth Circuit decision is
But it rubber
a
stamped
memorandum disposition.
But it rubber stamped it.
But it doesn't. It's not binding on us. It's not binding authority.
And if you read it basically said if they think there's 25 houses and they complain and they deny it on that claim on the duty to defend, so be it. There's no factual dispute there. Where in this case, the facts say 4 houses, so you got to go back in time where there's no coverage to get houses, and then you got to front time some more houses. If they want that policy in Washington, Seattle, the court's right to cite Seattle Tunnel because it's a project policy. If they wanted a project policy to cover all phases, all development of all time, they should have issued it. The average person reading that policy would not think an occurrence 6 years later, 2 years, 1 year, whatever it is, would trigger an exclusion and deny coverage.
Counsel, would you like to reserve the balance of your time for
That'd be
rebuttal?
fine. Thank you, Honor.
May it please the court, Chance Laboda on behalf of TIG Insurance Company. This is really a simple question of policy interpretation. TIG is not up here. It's just up here asking you to enforce the policy as written. Washington law is clear that if, based on policy interpretation, that clear and unambiguous policy terms must be given, must be enforced as written, and that's all TIG is asking you to do today. The tract housing exclusion or endorsement explicitly excludes coverage for tract housing developments that are 25 or more buildings built by an insured in any and all phases of a project or development. This language has been enforced as plain and unambiguous by this court. I want to briefly address.
You're talking about Hay.
Yes, in Hay, yes. And in that case, this court explicitly held, it explicitly held that neither is susceptible to competing interpretations, at least none that are unassailable.
I'm sorry, you mumbled. I couldn't understand what
Oh,
you just
sorry, I was just reading the log, or the Hay decision. The court ruled that the exclusion is unassailable and not open to, susceptible to competing interpretations.
You say the conclusion's unassailable. What conclusion are you talking about?
That the tract housing endorsement applied to exclude coverage.
Yeah, again, how does that help me? You give me the facts. It applies to that one, okay, but
Well, in this
okay, it
case,
applies to them.
Highmark built 25 homes. It's not reasonably in dispute that this project did not involve more than 25 homes. And so, this is the bargain for insurance that was purchased by Highmark. TIG sold the policy, but that is the policy that Highmark chose to purchase.
Well, he says this wasn't a real project. As you
Right.
might think about a project. You think about, well, I'm a developer, I'm going to build 45 homes.
Yeah.
And, but it takes time to build 45 homes. He says that's not what this was. Project like that takes phases and, whatever, may take years. This, he says, was basically, he says each home was an individual project.
Right. I'm not sure that issue was properly briefed before this court, but I also don't think it's
What do you make of, what do you make of it?
I don't think it's reasonably in dispute. I mean, the Vintage Hills project contained much more than 25 homes, and Highmark was the developer on all of them. The fact that it took multiple years and each house is built individually, that's how housing developments work. You build them in phases, phase one, phase two, and it of course it takes over, it takes time, but I don't think whether one house was built and then they moved on to the other house disqualifies it as a phase or development. And I don't think the appellate's cite to any case law that supports that position.
Was there an overall, you have to go to the county or wherever, the city, to get the permits. Was it presented as like this is a 100 tract home?
It was, Your Honor. It was submitted as a plat to the county that, each house was individually laid out, and then Highmark went in and built each house individually and got certificate of occupancies individually. But it was all part of the same development that was submitted to the city of Bremerton, I believe. Mm-hmm. Yeah. Appellate cite to the case Seattle Tunnel Partners, which is a case that does not apply to the facts of this case. It was cited to at the lower level to clear up some policy language. It basically was cited to show the language, how courts are to interpret policies in the state of Washington. But Seattle Tunnels Partners is a first-party property case that covers specific covered perils. In this case, we're dealing with a general liability policy that is a yearly policy and is really, the trigger in a CGL policy is property damage caused by an occurrence. The trigger in a first-party all-risk policy is, covered perils unless explicitly excluded. So they really are an opposite. And the rationale in Seattle Tunnel Partners does not apply to the facts of this case. Another thing is that the tract housing exclusion, it does not modify the insuring agreement. The insuring agreement stays the same. Rather, it is a limitation on certain types of coverages that was bargained for by Highmark when they purchased it. They being Highmark, explicitly chose to buy a policy that limited coverage to 25 or less homes. If they had built 22 homes, the tract housing exclusion wouldn't apply, but it's the 25 or more homes that makes the tract exclusion apply. These types of mandatory endorsements are routinely upheld and are part of, the insurance procurement process. It affects premiums and how much the insured elects or, wants to pay. I think the facts of this case show that there's two policies at issue here. There's the Hanover policy, which was wasting. And because it was wasting, in theory, Highmark decided to get a second CGL policy. But this policy explicitly excluded coverage for 25 or more homes in any and all phases. So the two policies, one wasting, one with a tract housing exclusion, that's simply the insurance that Highmark chose to purchase to insure their risks. It does not modify the insuring agreement. The insuring agreement still covers property damage caused by an occurrence. It is simply just a limitation on the type of coverage that is available.
So explain to me a little bit more in layman's terms, what was actually covered then?
Well, the insuring agreement itself covers property damage caused by an occurrence or bodily injury. So if, it was a single project and Highmark put up the home or a single house in the project and the roof leaked and got down into the flooring, then, the cost to repair the flooring would have been covered. It doesn't change the type of coverage available. It's just as soon as you build 26 homes and all the roofs leak and get down into the flooring, then you have a limitation on the coverage, and the tract housing applies to eliminate coverage for that type of project.
There was a determination in a prior proceeding that Highmark was in fact liable for some of these home construction defects, correct? This was before they assigned their claims to the homeowners.
I don't know if it was a finding, but they did settle the case. And sure. There
was a judgment against Highmark.
Correct.
For the construction defects.
Right.
And then the plaintiffs who received that judgment in their favor against Highmark decided to pursue their claims directly as to TIG as opposed to Highmark. Correct? Okay. So there was no effort to be able to get their repairs made or whatnot through Highmark directly. Highmark said, here, you can just have our claims against TIG.
Correct. So the duty to indemnify is different than the duty to defend, however, and the duty to indemnify is based on actual coverage available under the policies. In this case, and it has been, repeatedly upheld through the courts, is that the CAT exclusion applies to preclude coverage. So that's why there's no indemnity obligation on behalf of TIG to go out and actually pay for what would be considered the necessary repairs in this case.
So once this endorsement kicked in, that's it. There was no coverage.
Correct, Your Honor.
Can you turn to the issue of the bad faith claim and why it is that you did not argue on appeal that these arguments had been waived? And what do we do with that now? Because I think that we would, had you preserved or made the argument that the bad faith arguments the plaintiffs now try to make are waived, we could perhaps address those as a waiver issue. But now that you didn't do that, I'm not sure we can do that, and you've only argued the merits. So
That's correct, Your Honor. And TIG thought it was necessary to address the claims on the merits, given the substantial exposure that comes with a bad faith claim and an allegation that they failed to defend. It was pertinent on TIG's part to get out
are
ahead
you
of it.
conceding that you waived the waiver?
I'm not sure we waived the waiver because you're talking explicitly about the motion for leave to amend, correct?
Talking about in this appeal,
Correct.
You never argued that the plaintiffs are raising arguments for the first time that were not raised below and, in fact, were precluded from being raised when their motion for leave to amend was denied.
I think you could say we waived it as it pertains to the motion for leave to amend, but the appellates also filed a motion for summary judgment at the lower court that did address bad faith claims, if I'm not mistaken.
Well, they raised a bad faith claim, but it was very different than the one that they're arguing on appeal.
Okay, right. And again, I think addressing the merits when the bad faith claim is out there is important from an insurance carrier's perspective doing business in the state of Washington. So the fact that the appellates in this case brought a bad faith claim, I think it was pertinent for TIG to address it and address it on the merits.
And you couldn't have said it's waived, but in the event the court finds it's not waived, here's our argument. You just said, here's our argument.
Looking back on it, I think that's probably what TIG should have done.
An extra little sentence might have helped.
Yeah,
Okay.
next time. But I guess to briefly address the bad faith argument, since it is before the court today, bad faith requires a finding of unreasonable, frivolous, or unfounded conduct by the carrier. In this case, there's a lot of back and forth about the duty to defend. I don't think the duty to defend is properly before this court. TIG picked up the defense immediately and defended through the settlement of this matter. The real question, or the real bad faith allegations, arise out of the failure to indemnify, which, as I previously stated, it has to do with the actual coverage available under the policy. TIG properly reserved on its rights, properly issued coverage position letters, defended throughout the whole time. They did at one point assign its own defense counsel, but assigning its own defense counsel is not an act of bad faith. In fact, this is not a consent policy. TIG had the right to assign defense counsel of its choice. There's a multitude of reasons of why an insurance company might choose to assign defense counsel, whether it be through conflict or past work experience. That's simply what happened in this case.
He came on the scene as the case was going to mediation. Is that right?
I believe it was a little before that, but yes, it's October 2017, I think is the time frame, which was around mediation.
Did he do the mediation, that lawyer, the new
They
lawyer?
were involved in mediation. I'm not sure if that attorney explicitly attended mediation, but they were involved and were sending correspondence back and forth between the parties or, other defense counsel. And to another point, there's allegations that TIG fired defense counsel. TIG never fired defense counsel. The original defense counsel stayed on and continued to defend the insured. It just so happens TIG brought in its own defense counsel to also assist in the defense being provided.
But TIG stopped paying them, the original counsel?
TIG began paying it for its own defense counsel. That's correct.
But continued to pay for
Continued to pay for defense counsel.
the old counsel?
Continued to pay for, no, they paid for their new counsel.
And Hanover paid
Correct.
for the old counsel. So
Correct.
That's the complaint about the burning policy.
Right, but Washington is a selective tender state.
Right.
And the fact that Highmark in this case elected to tender to both insurance carriers, that's out of the control of TIG. We can't, TIG can't, has no say on who gets tendered to. So, they elected to assign their own defense counsel and pay for it, but the Highmark was never left without a
Settlement
defense.
proposal made during the mediation by TIG?
I believe TIG made a offer prior to the mediation. I'd have to go back through the record to say for certain, but there was discussions about the proper amount for each homes. Mm-hmm. But when it came to mediation, TIG did not offer any money for settlement. But again, they didn't have any duty to indemnify based on the CAT exclusion, which that position was communicated to the insured prior to the mediation occurring. One last point I'll make is that throughout the pendency of this case, Highmark also had its own personal counsel involved in the case, and there's nothing in the record that reflects any displeasure on the behalf of Highmark with the defense being provided. It seems to be a issue being raised by the assignees in this case, post-settlement, where they're raising the issue of, whether defense counsel, properly acted and properly had the best interests of Highmark while conducting its defense. One last thing, Your Honors. The appellant's brief raises, or at the lower court, there's action or there's claims against TIG for violations of the Washington Administrative Code, IFCA, the CPA. Those claims were not addressed in the appellant's opening brief, and it's TIG's position that those have been waived and are not properly before this court.
Okay, thank you for your
Thank
argument.
you.
A couple things to unpack there, Your Honors. First of all, they acknowledge this is an occurrence policy in oral argument. They said this is an occurrence policy. There can only be occurrences for houses that are built. Houses that are built can't have damages because they haven't occurred. The actual construction hasn't occurred during that policy period. So 4 houses built in the first policy period, there can be 4 occurrences. The 21 other occurrences cannot occur till the houses are built, right? That is why they should not be able to add them together. You read this policy as a complete policy, 1 year at a time. Seattle Pacific, the Seattle Tunnel, the reason the court needed that analogy is because it needed the time frame to be a policy period, or a project policy. It's not, the court didn't realize it wasn't a project policy. That's why if it went back and read the actual record, you'll find it's a 78 or 72-month policy. And so that's the proper way to read a policy. There's not another case in the state of Washington history that has ever extended a policy to deny coverage like they're trying to do. Never. There's not a single one. There's the pollution cases where they've triggered coverage because there's a tangential connection because the pollution continues. There is no connection between the 4 houses in one policy period and the 21 houses. They have distinct certificate of occupancies. In a CGL policy, once they're built, then there's completed operations coverage. So there's coverage to the end of the policy period, then coverage is over. Their own denial letters say that. There's no coverage for those houses.
Excuse me, let me do it this way. I understand that these are 3 successive policies for 1 year each. I get that.
Yes.
What if you have a policy that has an exclusion that says we will not cover damage caused by water pollution?
Okay.
And it doesn't say with respect to policy period, it just says we will not cover that. Well, here we have something that says we don't cover tract houses, and it defines tract houses. Why do we say, but there has to be a tract house built within the year?
The answer to that is, if this was an apartment project where there's different occurrences that transcended a policy period, i.e. their certificate of occupancy is the defining point, right? Where the completed operations is. That's where the current has to occur for the damage. So it actually goes across the policy periods, right? So you'd want that language in that policy, right? There's several, there's the Ballard case, it's the Ballard Square case. It talks about the same kind of analysis. Like, well, of course they should be covered because the construction, you can't tell when that damage occurred before or after the occurrence happened in this policy period. Therefore, they counted the whole project. This is individual certificate of occupancies that have definite points of completion where coverage doesn't
Let me ask
occur.
you a different question. Did Highmark construct tract housing?
Not as they define it, and I want to be careful when I say this, Your Honor.
Now, how do you define it then? What's tract
The
housing
fact,
in your
if
view?
they were not the developer of this project, I don't know if...
Let me ask you a question.
Okay.
How would you define tract housing?
I would identify it as the guy that initially submitted the plans for the entire plat. Council mentioned this wasn't a development, right? A project. That guy went into bankruptcy. It's in the work, the paperwork. So what happened was it went into bankruptcy. Once it went into bankruptcy, Highmark came along, and I don't know how many houses were built beforehand, but it started buying or doing individual lots. Does that make sense?
Let me ask the question in a different way. Is the housing at the Vintage Hills project tract housing?
Not according to the city, it wouldn't be. Read the city ordinances is how they submitted the paperwork for each house individually. The original developer, it was tract housing because it submitted a development project plat and development. Once he went bankrupt and Highmark came in and started submitting individual plans for each house, and each house had to be individually approved. Whereas the original developer came in and said, here's everything we're going to build. Here's our plat. Here's our tract housing, right? But that's not what Highmark did. It came in after the project tract housing was all developed. It went bankrupt, and then it started submitting individual houses to be built. Does that make sense? A couple more things. There was not concurrent coverage here.
Is that in the record?
Yes, it is in the record. Council misspoke when he said there's concurrent coverage.
Councilor, you're over your time, so if you could wrap up, I'd appreciate it.
Yeah, there was not concurrent coverage. It was 3 consecutive policies by TIG and then policies issued to Hanover. But there weren't concurrent coverage for the same risk. They were separate risk. 3 policies, all consecutive.
Thank you for your argument. Thank you. This case is now submitted, and the court will stand in recess. Thank you.